Quando muito for um bulala gap. Sapa muito kutengenza katangizi. Yaphela ufuna umbulala.
Yes.
I call the matter of Zuma and Thales, Deputy KZN and others.
Statements.
All that when we adjourned, we were asked to talk about what seemed to be a dispute at the time, and the position was that if we need this document, we must apply, which we have done. I wish to hand up an application to this court. I hand up the copies. As the court, please.
Thank you. Mrs. Kakane, we have now received your application. How do you propose we deal with this matter henceforth?
May I haven't read the answer from the state. May I propose that we adjourn, that I consider the
Can we perhaps maybe stand your reply down and ask Mr. Cat to deal with his reply? Then we can in the interim consider what the answer.
I would make the same. I would request the second ruling that we be excused to leave the court in the meantime to consider the affidavit, if that is.
How much time do you think you need
I'll need 10 minutes. I'll need 10 minutes. Anton, second. My Lord, there's a suggestion that I read while I'm here, which is difficult while Mr. Katz is talking, but I will do it.
So no, we don't want to. Can we give you 15 minutes?
How many pages is it? No, guys, I think we must first give Mr. I think we must give Mr. Katz the opportunity to argue. We must give Mr. Sikakane, then we adjourn. Then Mr. Sikakane can read some, and then we have time. If it stands down for...
So we were saying we can read whilst
we can read while the reply is
Mr. Kat, are you happy with, have you seen this after answering affidavit? Have you seen these papers at all?
My instructions are we receive the answer but not the founder.
Not the founder.
But I'm happy
are you happy to
I'm happy to continue with the reply.
Because we're trying to save time.
Yes, I would wish to continue my reply.
So this is why we actually wanted to start at 9, so that we don't run out of time.
I'm happy to...
Are you happy to
reply?
To
yes.
reply.
Yes.
Can you allow him to reply?
We can give extra time when we need me.
So I'll address the reply. As far as this application is concerned, the new application is concerned, it's not entirely clear to me that that my client has any rights in respect to it because it's in the Zuma application, not in our bid. My lord, my ladies, as far as the reply is concerned, there are 4 topics that I intend to deal with. The 4 topics are the 3 grounds of the challenge to Mr. Abrams' decision. Those are the 3 topics, the first 3 topics that I'll deal with. And then the last topic is the permanent stay. Now, by way of introduction, what I intend to do is to deal with what we call the second ground of challenge to Mr. Abrams' decision. That is the prosecution policy issue. Then I'll deal with the powers issue, and then I'll deal with rationality, and thereafter the permanent stay. Now, on a high level, we've listened to our learned friends, Mr. Trengrove and Mr. Breitenbach, and what we submit is that many of the legal principles that they articulate are in accordance with our understanding of those legal principles. And I'll demonstrate those principles as I go through the argument. But what we submit is that those legal principles applied to the facts generate, and we submit, a conclusion that we are entitled to Pres 1, 2, and 3. So if the court accepts the principles that Mr. Trengrove articulates and that Mr. Breitenbach articulates, we must win. And if I turn to the prosecution policy itself, that's the first big chapter in my presentation, we agree with our learned friends that when it comes to the prosecution policy, the special reasons articulated in Chapter 4, Part B of the prosecution policy are not ring-fenced by those bullet points because of the word "these include." So there can be any special reason, even those outside the bullet points, which allow for the usual rule, the normal rule, as the prosecution policy says, that when an accused is informed there will not be a prosecution, that should be the end of the matter. It is only in special circumstances that the prosecution may start a case again. In the words of Brandtje, make an original, different decision. Now, the first proposition that we wish to address on this issue is that all that special reasons does, or that a special reason would do, is to trigger the power of the prosecutor to review. And once the triggering mechanism comes into operation, the jurisdictional fact is present, the special reason, then the discretion of the prosecutor kicks in, and the prosecutor will take into account all the types of factors that a prosecutor takes into account every day when it comes to prosecution. But there has to be a special reason. And without a special reason, the decision would be unlawful. So what our learned friends suggest is that there are two reasons why a special reason existed for Mr. Abrams to be able to exercise a discretion. And the first is that the original decision in respect of Thales was clearly wrong. And the second is, well, in any event, it's obvious. The decision was in respect of Thales by Mr. Mshe was based on this unlawful decision of Mr. Mshe in respect of Zuma. Therefore, that's a special reason. And we submit two reasons on the facts. The facts one will find for purposes of this debate at page 41 of the record, paragraphs 174 and 175, where in the founding affidavit, the following is said by Thales. 174, the factual averment is made. The charges were lawfully and validly withdrawn against Thales in 2009 in a separate and self-standing decision. 175, the decision to withdraw must be regarded as valid and lawful as it not been held to be invalid and set aside by a competent court. So there are three aspects. Separate.
Mr. Katz, you can assume in our favors that we've read these paragraphs, but the fact that it was validly and lawfully withdrawn previously, how does that impact on the fact that it can then not be instituted again validly in terms of the policy as you?
No, I'll come to that. I will come to the answer. So, may I just finish the argument and let you? So the idea is that you have a separate the answer to this you will find on page 192 at paragraph 181, where Mr. Downer says, I admit these paragraphs. So we have three aspects. A separate and self-standing decision, which is valid and lawful. It can never be regarded as clearly wrong on the admitted facts. It's valid, it's separate, it's self-standing, and to suggest that it's clearly wrong is without merit. It cannot, and as well as on page 204 in paragraph 212.2.
Sorry, second, just please leave the courtroom. Yes. The one with the cell phone, can you leave the courtroom? Is it you who's... The cell phone that was ringing.
Oh. Sorry, Mr. Katz.
No, sorry.
I think everyone should switch off.
And the second point, Ms. Adhikari reminds me, is that in 212, from paragraph 212, paragraph 2 on page 204, Mr. Dana effectively accepts that the decision to withdraw against Thales was rational. Now, a rational, lawful decision, separate and self-standing, can never be clearly wrong. Never. So then the question is, well, what is the special reason? And they say it's obvious. The shared decision vis-a-vis Mr. Zuma was irrational, unlawful, and they rely on that. My answer to that is fourfold. One is, a special reason to move away from the normal situation can never include conduct by the NPA, which is unlawful, backed up by what Mr. Trengrove, we submit, correctly described as bad faith litigation by them in defending the DA case, in respect of another prosecution, which is the Zuma prosecution, in respect, the fourth point is in respect of Thales, where Thales had no role at all in the unlawful, irrational, backed up by bad faith litigation unrelated to Thales. How can that be a special reason vis-a-vis Thales? And we submit it cannot be, ever. And we add to that there's a suggestion that Thales were the incidental beneficiary of the unlawful conduct by them, by the unlawful conduct of the NPA. We turn it around and say, no, Thales were not the incidental beneficiary. They were the unfortunate victim of the NPA's unlawful conduct backed up by bad faith litigation. And the court will...
Can I just ask this? I think we debated this issue on Tuesday. When Mr. Mshe made his decision, at the time, he made it. And because he made that decision against Mr. Zuma, or in favor of Mr. Zuma, he also made it in favor of Thales. That decision was then found to be unlawful by the court, but not by him, but by the court, because he did not review his own decision. So it is the court that pronounced on that decision that it was unlawful. Then because that decision by Mr. Mshe was unlawful, and I think we went through this on Tuesday, that is I think we accepted to some extent that Thales charges were withdrawn because of the withdrawal by Mr. Zuma. And because the court has found that that decision was unlawful, isn't that a special reason for them then to recharge Thales?
My answer, yes. Thank you. I know we did debate this, and I have an answer on three levels. The first is, factually, Dana accepts that the decision vis-a-vis Thales was separate and self-standing.
But do we have to rely on Downer as the court?
Excuse me?
Must we rely on Downer as the court when we make our own finding?
No, with respect, it's a factual issue. Was Mshe's decision vis-a-vis Thales separate and self-standing or not? Downer says it is. That's what the court will have to accept.
I think, Mr. Katz, really the issue when we debated this proposition on Tuesday was that the unlawful decision of Mr. Mshe was a catalyst to the withdrawal of the charge against Thales. That's a core issue.
I was coming to the second answer in respect of Justice Poyo Lawati. So the first issue, on a factual level, it's a separate and self-standing issue. The second issue is what your ladyship put to me was this. The court set it aside, and that was the trigger. And we answer no, that wasn't the trigger. The trigger was, it was unlawful. Ex tunc. It wasn't that the court, all that the court is, declared something that was unlawful. So it's not so the October 27 decision of ENAFSA ADP wasn't the true trigger. The trigger was Mshe's unlawful decision vis-a-vis Zuma. The fact that the court declared it 8 years later, is just declaring what is, which is unlawful. And all that we submit is that if the court comes to the conclusion that the NPA are allowed to act unlawfully, backed up by bad faith litigation, in respect of another matter, not my client's matter, in respect of which my client had no role to play at all, if that's a special reason, then the court will find that.
But then that's the problem, because you are distinguishing and separating Thales altogether from Mr. Zuma. And that's why more than 2 times I said, let's go to the indictment and see the interlink. Because unless we make that connection, or unless there is a connection, then we will have it in the manner.
I accept what you say, Justice Poyat-Lawati. All my submission is, for Abrams to have made a lawful decision, the court will have to find on an objective basis that there was a special reason. And I think Mr. Trengrove accepts that. And the only issue that I'm submitting is that a special reason in these types of circumstances can never be one when it is based on not the court finding in October 27, it's that Mshe acted unlawfully in April 2009. He backed it up, not Mshe, the NPA acted unlawfully. The NPA backed it up by opposing the litigation. I heard the words yesterday, bad faith litigation. It had nothing to do with the decision, the unlawful bad faith litigation had nothing to do with my client. And as a matter of principle, I mean, it was a different decision. And my client had no role to play in the unlawfulness. It wasn't as if my client encouraged the unlawfulness, the Zana principle that they spoke of yesterday. My client had nothing to do with the decision that Mshe had vis-a-vis Zuma. And if the court finds that, despite all my proposition, that was a special reason for Mr. Abrams to reconsider, well, then the court will find that. But those are my submissions. That is not a special reason. Excuse me. Yes, and the principle is, yes, I have to add the 5th leg, that there was, because of those 4 features, I add in the 5th feature that there's massive prejudice to Thales. Can't ignore it. As if we could just wipe it away. Not fair. So to the extent that it is said that we were the incidental beneficiary of Mshe's unlawful decision by them, we say no. We were the unfortunate victims of the unlawfulness, that 9 years later, the normal rule which would apply to us was suddenly given a special reason why that normal rule should be dislodged. So those are submissions on the prosecution policy. Turning to the powers point. Again, we agree with Mr. Trengrove's approach and analysis on a particular aspect. We don't agree with his conclusions, but his analysis was this, and we submit for good reason. His analysis was, when the court decides whether Abrams had the power, the court's role is to look at 179.2. That's how I understood it. He did add, as he developed his argument, that it wasn't really important, but in any event, the NPA Act itself does generate the same power, if I understood the argument correctly. But his primary argument, correctly so, was that it's to 179.2 that the court turns. And we would recommend that in determining that issue, and I'll turn to the merits of that, but I just want to stop and say why he was correct in that analysis, is because of paragraphs 58 and 59 of the Zuma versus DA case, where the court will recall the reason that the NPA conceded the Mshe unlawfulness. It's page 40 of my bundle. The reason, it's important that we just step back, if I may just take the court a step back. Mshe made his decision to withdraw against Zuma on the basis of 179.5 of the Constitution. What the NPA did, with which Mr. Zuma agreed, was to, at the 11th hour, after 8 years of bad faith litigation, say the following. Mshe, we relied on the wrong provision. And that one sees in 58 and 59, I'll read the first sentence of 59. Faced with this seemingly insuperable difficulty in relation to Mshe's incorrect invocation of 179.5, the decision was liable to be set aside. That's what the NPA conceded. So Mr. Trengrove, we submit, was driven, and he correctly did this. He was driven to 179.2 because that's what Abrams relied upon. That's what Abrams invoked. And it's no good with respect to his lordship, your ladyships, to say, well, 22.1, 22.9 are applicable. Abrams told the world, tells the court, I'm deciding against you, Thales, in terms of 179.2. And Mr. Trengrove correctly focused his attention on that. That was the power that Mr. Abrams relied upon.
But you see, if you want to cite to us what Mr. Trengrove had submitted on the score, then most certainly one must also look that section 22 sub 1 gives effect to section 179 sub 2.
Unfortunately, the Zuma versus DA case says, in terms, that is not what a prosecutor may do. So it said it in terms. Let me read you from Liebenberg.
Let's go to that specific provision where you say that Justice Nafsa says that is
well,
not.
if I may just read from paragraph 58, where is reference to the minority, not in respect of the majority didn't disagree with, in the Liebenberg case. After J, and I quote, in our law, administrative functions performed in terms of incorrect provisions are invalid, even if, this is your ladyship's question to me, even if the functionary is empowered to perform the function by another provision. In accordance with this principle, where a functionary deliberately chooses a provision in terms of which it performs an administrative function, but it turns out that the chosen provision does not, the function cannot be saved from invalidity by the existence of authority in a different provision. That's the point. And that's why Mshe's decision was set aside. That's why the NPA conceded it. And Mr. Trengrove knows that. And that's why he was driven to 179.2. He's acting for the NPA. In October 27, they conceded on this very proposition. Now we are in May 2019. Why does Mr. Trengrove do it? Because he knows what the SCA says. So if your lordship and your ladyships rely on 22.1 or 22.9 or any other provision which Abrams doesn't mention in his letter or in his affidavit, the court will be violating what the Constitutional Court has and the SCA have said about the invocation of powers. And we submit that the court will not do that. At the point that I made on Tuesday in the Harris case, this court is bound by what Mr. Abrams invoked. If he got it right, no problem on the powers point. He got it wrong, the problem. So now we turn to what Mr. Trengrove submitted about one, and what you cannot do with respect is look at the legislation to give effect to the Constitution. That principle is as old as the hills. But and under the common law, no court could look at a regulation to give effect to a statute. Similarly, under the Constitution, no court can look at a statute to give effect to the Constitution or interpret the Constitution. This court must interpret 179.2 and determine, does it give Mr. Abrams the power, yes or no? If it's yes, no problem. If it's no, there's a problem. And we turn to page 179. And what Mr. Trengrove did with respect was he criticized me for having blinkers on when it came to the interpretation of 22.1. The court will recall. He said that I looked at 22.1 without looking at the context, etc. And our counterpoint is that's exactly what he did as far as 179.2. He looked at the words, he gave the court an interpretation, and your lordship and your ladyships recall, not once did Mr. Trengrove mention three things: the context, the history, and the purpose of 179. And this court has a duty, with respect, to look at those four aspects: its text, context, history, and purpose. And then you will come to a decision as to whether 179.2 does give the power that Abrams invoked when he made his decision. But what you cannot do, as we would submit, in a constitutional setting of this kind, ignore the history of 179, where did it come from, what was its purpose, what was its context, and then, as part of that, you can look at the text. And the cases on interpretation of a constitutional provision are now legendary. They're trite. We've given them to you. It's Indemani, the judgment of the SCA. It's Faria, judgment of the Constitutional Court, and a whole range of others. We've given them to you. But what you cannot do is put Mr. Trengrove's blinkers on and say, these are the words, there's the power. Now, as far as history and context is concerned and purpose, the court knows from the history that prior to 96, there were silos when it came to prosecution. Each Attorney General had his own silo.
You mean prior to 94?
Let's just not go there again.
No, we've
please.
dealt
Can we
with
just
that.
move
No,
on?
no,
Yeah,
I accept that.
we've
So in
dealt
other words,
with
if the court accepts my history and my purpose as part of your interpretation exercise, I can have no problem.
But the history and the purpose have been also dealt with by Harms in his decision dealing with the Nicholson judgment.
No?
Yes, the
Not-
history of the Attorney Generals, look, if you
with
carefully
respect-
consider that, Mr. Katz,
Yeah,
you
no,
would see it.
Absolutely, and we put it in our head, and let me answer it like this. That history and purpose that Harms and DP dealt with was entirely different on the ratio and the arbiter in respect of the challenge that's now before the court. It's a different challenge in respect of a different issue. This is a powers argument. And Harms DP did not deal...
Yes, but Mr. Pratt, you dealt with the history. And choose.
I'm not going to deal
Please,
with
we
it.
don't want to hear it again.
I'm only arguing that Mr. Trengo's interpretation was limited to the text. And we submit this court has a duty to go beyond the text, no more than that. You know the reasons, you know, the court knows what our tools of interpretation, speciality, etc. The third aspect is rationality. And again, I have to say, Mr. Trengrove is right in his principle. And the principle is this. He criticized me, and we submit correctly, for taking the view, so he said, that Mr. Abrams did not have the power to review his own decision. Remember, I had made the submission that he couldn't do so because of the notion that one decision maker cannot, under 179.5, review his own decision. And he put me right. And he said that no, that wasn't what Abrams was doing in considering Thales' representations, and he was quite right. What Thales was doing, so he argued, was continuing to decide whether Mr. Abrams, what he was doing was, in terms of the prosecution policy and in terms of the protocols, he was continuing to decide whether Thales should be prosecuted. That was Mr. Trengrove said. And he said correctly that Mr. Abrams considered the memo by Downer, which dealt with Thales' representations. The court will recall this. So I was, to the extent that I made the submission that Abrams wasn't entitled to review his own decision under 179.5, and I was corrected about that, I accept that the principle. But then he runs into a problem, a major problem on rationality. Because if it is so that Abrams was continuing to decide whether to prosecute Thales on the basis of Thales' representations, then we have to, and all that Abrams had regard to at that stage, so he says, is Mr. Downer's memoranda, or the prosecution team's memoranda, of which the court will find. The date is 28 June 2018. Mr. Trengrove corrected me. That's 528, 529. The prosecution team says, your court will see it on 528, it says to Advocate Abrams from the prosecution team, response to representations received from Thales. And we go on, and there's various paragraphs, and the conclusion is not to accede to the representations. But the difficulty from a rationality perspective is this. On page 530, Mr. Downer says, or the prosecution team say, under heading, the delay instituting the prosecution and or unfair trial. So now, Mr. Abrams has to consider on Mr. Trengrove's argument, not as a review, but as an ongoing decision. Is the delay and the unfair trial issue, is it something that I should consider in this picture of deciding whether to prosecute Thales? And this is what the prosecution team say, paragraph 3.2.3. Discontinuation of prosecution as a result of a delay, and we emphasize the following words, can only be ordered by a court of law, not the NPA. If the court is in agreement with that statement, well, then I have no rationality argument. But if the court comes to the conclusion that Abrams did have the discretion to discontinue, and he did have the discretion to consider the delay and the unfairness of the trial, then the prosecution team's memo led Abrams up the garden path. And he went wrong. He couldn't have gone right because he didn't know he had the power. How could it ever be rational on the authorities of the Constitutional Court for a decision maker to be told, oh, there's one factor that you can't decide, but a court must decide when that's not true. He can decide. And your ladyships and your lordship will decide, was Abrams led up the garden path, or did he properly apply his mind to the exercise of his discretion? And we submit that the answer is obvious when one reads those words. He can only be ordered by a court of law and not by the NPA. You, Abrams, are told you can't make the decision on this aspect, and therefore he didn't. He doesn't disavow, he doesn't say he did apply his mind to it, he couldn't. He says that you know what his answer is. His answer is, I reject them because the NPA have reasonable prospects of escape. That's his reason, no other reason. Now, if the court finds that it's rational for a decision maker to have his eyes having been closed, well, then we have to live with it. That's what the court. We've given you the cases all day, Northwest Townships, etc. We've given you the cases. The Constitutional Court, SCA, have said over and over and over, where there is a closed door to a discretion, when a decision maker who's exercising discretion has part of his discretion closed, it's vitiated. So I turn to the permanent stay. Now, in the permanent stay, I'm going to end with reference to something that your ladyship pricked my ears about yesterday. When she said to Mr. Breitenbach, what about Naidu? Now the court, and I'll end with that, but before I get there, because it's quite crucial to how this court considers the permanent stay. On the question of delay, there was much debate between the bench and Ms. Adhikari, on the question of how much time. Was it 9 years? Was it 14 years? Was it 15 years? And I want to leave aside the debate subject to one thing. His Lordship made the point yesterday that the decision in October 2004 to withdraw against Thales was motivated, as Dana says and Mr. Nguka says, by two features. The one was the agreement issue, the dishonoring of the agreement issue, and the second was pragmatism. Now, it seemed through the debate that the court was appreciative of our argument that there is no way the NPA can rely on a dishonoring of an agreement which took place in May. They knew about it on May the 22nd, 2004. But on the 11th of October, how many months later, 5 or 6 months later, they say, well, we're honoring the agreement, even though they knew in May that there was a dishonoring of the agreement. We submit that's just not plausible. It's not fair, and no court will accept that type of argument. So then one comes to pragmatism. Well, if pragmatism was an issue, why was it an issue in 2003 when they were prosecuted? It redounds against the NPA, not for them, that in October 2004, they withdrew against Tully for pragmatic reasons. What are these pragmatic reasons? They didn't want to interfere with the Sheikh trial. They might have delayed this because of a disagreement which might have been debated. And then wait until November 2005 to reinstitute the prosecution after Mr. Zuma had been accused in July 2005 post the Sheikh trial. If anything, that period of time from 2004 through to November 2003 all the way to 2005 and I'll track through to 2006 in a second, is part of what we would call unreasonable delay by the NPA, alone for unjustifiable reasons.
Sorry, 2003 or 2004?
2000.
Well, they were first. Excuse me, Marie.
No, but is it 2003 or 2004? Because I would imagine it's 2004
No.
The
May.
agreement was in
2004 in May.
Yeah.
As it
When,
pleases
when
the
the
court.
first, so 2004 May until November 2005. You say that
as
is
a start.
attributable.
As a start.
Yes.
As a start. Then your ladyship made a very, with respect, a point about the search warrant litigation. The court will recall that yesterday, with the debate with Mr. Breitenbach, one of the points that your ladyship raised was in the search warrant litigation, some of the applicants were not accused. Well, from the 20th of September 2006, Mr. Zuma and Thales were not accused because Umsamang struck the matter of the roll. So post September 2006, they were not accused.
I think, Mr. Katz, it's taken out of context if that's the way that Thales sees this questioning from the bench. Because stricto sensu, one will only reach the end of that situation of no longer being an accused person once there is an outcome of a matter. And in that in this matter, there was no outcome. The reason why I asked Mr. Breitenbach those questions is because it was about who is to be blamed
No.
for the delay, and because the mention was made of the search warrant litigation that impacted on the progress of the prosecution, the question had to be asked that the search warrant litigation wasn't only accused persons,
Yes,
it
I
was
accept
also other people
No, I accept that.
asserting their
No, I accept that. Absolutely
constitutional
right.
rights.
But the point I'll make is this, on the Zana principle,
Yes.
in buying into your ladyship's point, if I may say, the Zana principle is, we disagree with the articulation of the Zana principle, because Maya P. didn't say what has been articulated as the
Well, she was
principle.
acting then.
As-
AJA.
as a piece.
Yes.
But Maya P. as she is now.
Yeah.
The principle that she articulated was somewhat different. I just want to come back to my point about the
Yeah.
September 20, 2006. To the extent that there can be criticism time delay-wise against Thales for the search warrant litigation, it disappears in September 2006, the criticism. That's all I'm saying. Because from 2000, and Mr. Zuma for that matter, because from September 2006, there can be no suggestion that the search warrant litigation which continued could be regarded as the fault or contributing to the delay. That's the proposition that I'm making.
But those, I know that for Thales they ended in September 2006, you say, but there was an appeal further on by Mr. Zuma and others to the Concord, I think not up to 2008.
No, sorry.
Was it
no,
not
no,
so?
no, Justice Boyer, I'm making a different point. Sorry, let me just correct.
Yeah.
In September 2006,
Yeah.
the matter was struck off the roll.
Yeah.
What then happened, Thales also continued to the Constitutional Court. That's the Tint judgment.
Yes, yes.
But that litigation was by Mr. Zuma and by Thales,
Yes.
was at a time when they weren't accused. That's what I'm saying.
But yes, but then it comes back to the issue that the prosecution team says they could not recharge because they were waiting for this litigation, and to some extent, to the extent that they were still pursuing the matter, it doesn't mean that you were no longer suspects.
You see, there was no clarity or there was no adjudication on
Yes.
on those whether the evidences were sourced by through those warrants could be used against any person. So they had to wait for the litigation to be finalized so that they can, there could be a determination by a court.
Let me, paragraph 65 of the Constitutional Court judgment in Tint makes it clear the difficulties that the prosecution team faces with these types of issues. And I can't
And
get
I was going to come back to that because it's the same argument in a way about Piccoli recharging and then he was not ready. So when do you charge? Do you charge when you are fully ready or when you're whole invested? So
I understand.
Yeah.
Those are all difficulties that the NPA face, and one has to accept that. One can't get away from that. That doesn't mean to say with respect, that Thales itself could be regarded as responsible in any way for that litigation. The worst that you can have for Thales on this issue, is the delay from November 2005 to September 2006. That's the worst. So when one does the McCarthy checklist of the time periods, they were charged into November 2005. They launched the search warrant litigation and maybe other litigation, it's irrelevant. And in September 2006, that criticism against Thales fell away completely. So if we look from 2004, let's say May 2004 on the judge's questioning, to March 2018, the only period of time where there can be any criticism, legitimate criticism of Thales, is that period, November 2005 to September 2006. If it's a criticism, we submit it's not a criticism. You can't blame an accused for going to court to challenge that which it believes to be unlawful. But to excuse the NPA from any period during this long period from May 2004 to March 2018, that's the only period, a period of 10 months. Otherwise, that entire period we would submit as at the door of the NPA. That being so, yes, and Mr. Adhikari points out again, in determining the culpability or otherwise of Thales in this period, that's from early 2006 to the resolution of the issue by the Constitutional Court a couple of years later, the court will have to accept, we submit, that this was the first time in the history of South African law post-Constitution that the issue of pre-trial search warrant litigation was dealt with and finalized and settled. It was an issue that needed to be dealt with. And there was a dissent, so it's not as if it can be suggested that in that case there was any abuse or bad faith litigation by Thales. They lost the case on principles relating to interpreting the Section 28 of the NPA Act as it then stood. But the broad proposition that I'm making is this. When it comes to unreasonable delay, we submit that the facts are that from, let's say, May 2004 through to March 2018, the blame is at the door of the NPA and the NPA only, subject to November 2005 to September 2006, at best for the NPA. I give them those 10 months. And then I turn to the trial prejudice point, which is the, let's call it the Naidu debate, if I may say. Now, I was thinking last night back to the interchange between her ladyship and Mr. Breitenbach when she had regard to the list of authorities and it didn't include Naidu. And the court knows that our heads of argument in terms not only refers to Naidu but quotes Naidu. And may I turn to our learned friends' heads of argument on page 36, because we would submit this touches impeccably on this debate, and we submit that this court, and only this court, is the court that must deal with the, let's call it the trial prejudice unreasonable delay point, on the basis of Naidu. And I'll come to why. So we would submit that if this court follows its own precedent and its own reasoning, the court will deal with our trial prejudice point and will give us prayer through. I'll explain why.
That is only in relation to other matters listed from this division. I mean, we will be obliged to take into account what the Constitutional Court said and what the Supreme Court of Appeal says. But when, in the case of where there is a debate of a court of equal footing in our division, then that would be the one.
Let me go deeper than that. I accept on the question of the balancing. When we come to the merits of the question, of the
sorry, which page of the,
30,
of the NPA?
it's paragraph 73 and 74 of our learned friends' heads of argument. Page 36, correct. And I need to read those three paragraphs, 73, 74, and 75. And we would submit that, read with your ladyship's judgment in the Naidu case.
This is they refer to this, that's what I've asked, because they refer to the decision of Judge Hugo.
Yes, but the reason that they do that, sorry, maybe I step back.
Yes.
And I'm going to give a compliment to the court, if I may, or to two members of the court. The reason they do that is because this court got it right in Naidu, with respect, and it's not for me to argue, you can never argue the Guru, but it got it right in Naidu in our favour on the point.
Are you saying that because the two members of
And I
this
was
court,
not there.
It was
so-
Judge Chetty. I think Judge Chetty was
Yes.
sitting in your seat.
So they might have been wrong.
that's why I'm asking you whether you're saying it because two members of the court are
I'll
sitting
bring
in
sanity
this matter.
to them.
We'll put it this way. It would be interesting to see if the two judges go one way and Judge Poyatruwati dissents on this aspect. But let me say this. It's quite clear to me now, having heard the debate and thought about it last night at 2 a.m. I woke up in the morning and I read Naidu again. I read it at breakfast again this morning with my team. And I come to the conclusion, which is this. On Naidu, this court must deal with Prayer 3. Now, there is no other court to deal with it. There is no trial court to deal with it. Your ladyships and your lordship will deal with it on the four corners of Plascon Evans. And I'll explain why. And if your ladyship and your lordship, if you want to distinguish Naidu, you say, well, that's what we found there, but it was in a particular context because it was the regional court rather than the high court, your ladyship and lord, and I'll come to the debate. But let me turn to our learned
Well,
friends.
that was the crux of the matter.
Excuse me?
That was the crux of the matter, that it ought not to have been brought
Well,
in the
I'll-
regional court,
I'll-
and that the regional court did not have the necessary jurisdiction.
Well,
Yeah.
I will debate that, if I may. If I be given it. I understand the debate, Section 170 of the Constitution. I will come to it. But on page 36, this is what the state say. And let me say this, with respect. This litigant that we are in a list with is not any ordinary litigant. This is the NPA who are administering the Criminal Procedure Act, administering fair trial rights, and you'll have regard to what they say about how this thing works. So it's not just...
But to be fair, Naidu, it was a review.
You said the
that-
trial court.
Yes, yeah.
Excuse me,
We send it back to the trial court.
I'll tell you why in that case it was appropriate, but not in this case.
Yes.
I'll explain exactly why. Well, no, let me put it. I'll go deeper than that. I will explain that on your
It was a
ladyship.
review, and we
No, I
sent it back.
I know I didn't write it.
Yes, we
I will say the following:
yes.
that on the court's reasoning in Naidu, on the court's reasoning, you can start the orders. I'll come to it. I'll go to it in detail. This court, applying the Naidu principles, will decide Prayer 3. That's my submission. Now, but before I get there, I do want to turn to page 36 of our learned friend Yao, because it feeds into the Naidu ideas that your ladyship, your lordship and your ladyship articulated. Firstly, we say the NPA got it wrong as a matter of law. And I'll explain why. And that's something that the court will take into account. In paragraph 73, they say the CPA is the key legislation that regulates the process of criminal trials, which are aimed at ensuring fair trial. Its provisions are therefore interpreted to ensure that they promote the spirit, purpose, and objects of the Bill of Rights. Let's accept that. Paragraph 73. Because I'm going to come back to that with reference to Naidu. Then they say Section 342 capital A deals with delays, importantly, during the trial after an accused has pleaded to the charge, and there's a reference to another case of 2001. Now that's wrong as a matter of law, and your ladyship says so. 342A, according to your ladyship, with reference to the judgment of Binswaw J and Kluti J, says the following in paragraph 21. The court thereafter, that's reference to that case, this is on page 60 of my bundle, the court thereafter proceeded on an analysis of the 342A of the Act, this is your ladyship, and found, correctly in my view, that the provisions of 342 capital A do not apply to, importantly, events preceding institution of criminal proceedings. Quite correct. And we know that the text of 342A talks about pending proceedings. So then your ladyship makes this point, correctly in our view, that where there is a challenge to permanent delay, there are two types. The one type is when the delay relates to what your ladyship called intracurial, which is after the proceedings have commenced, and those which relate to events before. That's what your ladyship said. And there's a division. 342A applies to the former, and 342A doesn't apply to the latter. We submit quite correctly. And where our learned friends go wrong in paragraph 74, they have a reference to the plea. Of course, we know that 342 capital A section 3 gives the trial court different powers before plea and after plea. So they're wrong as a matter of law. And we ask that the court note that the prosecuting authority, in describing the key section in respect of the Criminal Procedure Act, which gives effect to criminal delay arguments, they got it wrong. Then they say it empowers the courts, I read back to the heads, to prevent abuse which result in the delays in the completion of the trial. The remedy applied by the courts occasioned by the abuse of court process is a stay of prosecution in terms of 342 capital A. They're perhaps right about that. As far as the plea issue is concerned, they're wrong. The section doesn't say what they suggest it says, it's just simply wrong. The relevance of all this is that we don't get the benefit of 342 capital A because our complaint, in the words of Her Ladyship, are to events preceding the institution of criminal proceedings. We don't complain about what happened after March 2018. We complain about what happened before March 2018. And if that is so, when I turn up at trial, because this court sends me to a trial, I'll go to my trial, my High Court trial, and I'll say to the trial, well, the full bench in the Thales matter said that they don't have jurisdiction, it's not appropriate, but it's the trial court to determine irreparable trial prejudice. I can't plead. Does the court invoke the Criminal Procedure Act and say, well, Thales refuses to plea, I impose a plea of not guilty. I plead not guilty. Mr. Downer stands up, he calls his first witness. What do? Do I sit? Do I object to the first witness? Do I have a trial within a trial? Which provision governs? We know it's not 342A, because that's what this court has found in London. So I have no 342A protection. Where is my protection? Here and now, in this civil court, High Court, sitting here. Your ladyships and your lordship are seized without section 35(3) complaint, and must deal with it. If you find that we're not entitled to a permanent stay because of the high bar, then that's what you will find. But what you cannot do, with respect, is send us to a trial court which has no power or no procedure to deal with this kind of complaint pre-trial of the kind.
Isn't that a very narrow interpretation of section 342 capital A, which was a response after the Sanderson's decision, and the courts were guided as to what factors to take into account, how to deal, and in particular instances, in extreme also award damages. You see, Mr. Katz, one must be very careful in dealing with section 342. I mean, and one has to understand also the NIDU in its context. Simply put, a matter that should have and ought to have been brought by motion proceedings were brought in front of a regional court magistrate that didn't have the necessary jurisdiction to entertain. But to read then there into that, I hear your argument regarding the fact that there wasn't suggestion that it's only at pleadings. That is not entirely as to what the Act says. But that does not mean that a trial court would not be able to deal with certain prejudices, because that's the duty of the trial judge.
I'll just read from what your ladyship found.
Yes, and we're fully aware of that. But what I'm trying to say is one must not narrowly interpret section 342 capital A, because it's placed in the Criminal Procedure Act for a reason.
With respect, my lady, it's not that I'm placing a narrow construction. It's the court. This is what the court said. It's not me. It's what at 2 o'clock in the morning in my hotel room. This is what I read. In my view, this is your ladyship, an application for a permanent stay not provided for in 342A must be brought before the High Court. Not me. It's your ladyship. And your ladyship is quite right. And your ladyship says, do not apply to events preceding the institution. So you have your ladyship found there was a bifurcated process. 342 is intracurial after March 2018 for my client. Outside the court process, which is before March 2018, 342A doesn't apply. It's not my interpretation. It's the full bench of this court's interpretation, which we submit is the correct interpretation. And if this court finds that it was wrong, then the court will have to find that it's wrong. And that my client may go along to the High Court and enjoy a 342A protection. But then this court will have to find that it was wrong. Yes, and let me so let me say that's on a procedural level. But on a more substantive level, why would the trial court be in a better position than this court to determine it in this sense? We've led evidence, they've led evidence, we've replied. There's a criticism of us that we're developing new arguments in reply, which I will deal with. But let's assume your ladyship sends me to the trial court, your ladyships and lordships send me to the trial court, and I raise my prejudice point there, and I stand up and I say, I have no witnesses. Tetard's gone, Perez's gone, etc. What does the trial court do? It can't do a 342A on this court's Naidu reading. So where does it turn? Where does it turn in the Criminal Procedure Act? Do I have a trial within a trial to determine what? In what circumstances? Is it before plea? After plea? Before Mr. Downer's first witness? After Mr. Downer's first witness? So Patricia Ms. DeLille gets into the witness box of the first witness, and I say, trial court, I object to DeLille's evidence because I can't cross-examine it. I can't even object when she says something that's here. I have no instructions. What does the trial court do? Can't do a 342A on this court's reading. What can it do? And I invite the court, or I can't invite the court to do anything, but I invite the court to consider what procedure my client could adopt under the Criminal Procedure Act or under any other legislation when it goes to trial and it complains about unfair, unreasonable delay outside 342 capital A. There is no provision. That's why we've come to this court, because this is the court and the only court that can. There is no other provision. We haven't been given any provision by the NPA. They haven't told your ladyships, your lordship. Your ladyships and in Naidu, the court went through it clearly and said, High Court. That's the answer. You come to court under 172(1)B and you say to the court, my rights are violated, a just and equal remedy is this. Yes, it's a high bar, but these are my facts. 4 corners of Plaster and Evans, and you decide it. And that's why we are here. And let me say this, my attorney reminds me, and I'd forgotten, the reason that we've done it in the way that we have, unlike our colleagues, is because I'd read Naidu before. I remember discussing this with Mr. Hellens. And I said, well, Naidu excludes us from that remedy. For us, we don't have a 342 capital A protection. You are my protection.
Well, you would not have had that bringing it in the regional court.
Excuse me?
That's the distinction. The regional court vis-a-vis and High Court. Yes.
With respect to his lordship presiding, we would submit that's a distinction without a difference for purposes of this debate.
I don't know.
And maybe make this point. Ms. Adhikari remind me, and it's an important
So
point.
if you want to tell, if by law you don't have jurisdiction to deal with the matter,
Excuse me?
Because the issue of jurisdiction, whether the regional court has jurisdiction to deal with the permanent stay in the manner they dealt with it in Naidu. But the High Court and regional courts are totally different.
If the court distinguishes on that basis, then the court will distinguish on that basis with reference to Section 170 of the Constitution. I understand
You're talking
it, but let me ask this question. If the High Court trial is now faced with our complaint,
they can deal with the matter.
How?
The High Court, yes.
How am I?
It's the High Court, not the regional court.
So I ask rhetorically. With respect.
You see,
That's very
I'm not
narrow
here to
interest.
answer your questions.
I'm
telling you, they have a jurisdiction to deal with the matter.
I understand.
I'm not here to answer
I'm not asking the question to answer. I'm not sorry, with respect, my lord. I'm not asking you to answer the question.
But that's exactly what you
No,
can
what I was
do.
saying rhetorically.
No, Mr. Katz, I think you must understand there is a distinction between the regional court and the High Court. I think you have to understand that.
And the difference, if the court rejects my submission and says the High Court does have jurisdiction,
Yes.
the trial court, then I'm going to
And
submit.
the case law says that case says exactly that.
No,
Naidu case.
Let me just finish. I'll make one more submission and then I leave this point. Two more submissions, one factual, one. If the court comes to the conclusion, in rejecting my Naidu point, that it is the High Court trial court that has jurisdiction, let's assume the court comes to that conclusion. My submission is, in this case, given its 15-year history, this court is inviting chaos. Because I will turn up at the High Court and I will say to the High Court, I can't get a fair.
But you will tell that judge
That-
there.
yes,
We
not-
definitely
no,
will
we're
not
not here
be
for
there.
that.
If
We're
you
not-
reach that point.
No, sorry, I'm
One
making
can
this-
double cross that bridge when you get there.
I'm making a different point, sorry, with respect. I'm making a different
No,
point.
we understand.
We understand your point.
I'm making this point. I have a right under the Constitution, under Section 38, to come to this court and ask for an order in terms of 172(1) of the Constitution. That's my right. A fair trial is a constitutional matter within this court's powers. That is the trigger for 172(1). This court must do certain things in terms of A, and in terms of B, it may do certain things. If this court says, yes, I have the jurisdiction, but we feel, as a court, that it's preferable that you go and raise these fair trial constitutional right arguments before the trial court, we submit that's not in the interest of justice, it's not just and equitable for a number of reasons. The first reason is that whatever evidence there is, as far as this irreparable trial prejudice, such as it may be, exists, it's before this court. There is no further issue as far as that's concerned. Number two, the Criminal Procedure Act specifies that in certain circumstances, an unfair or unreasonable delay issue is to be dealt with in a particular context. 342A. There is no provision in the Criminal Procedure Act that I know of, or that's been pointed out to me, or us, that exists in respect of non-342A situations. It doesn't exist. So the High Court trial will be faced with this argument, and the question that I pose is, why would it be just and equitable, the interest of justice, for that High Court trial to be confronted with these fair trial rights issues? Oh, leave it to that court when there is no procedure that is set out in legislation, is set out in regulations, is set out in the Constitution, that the trial court will utilize to come to our assistance or reject our claim. This court has the tools. This court is the appropriate court in the circumstances. So we would submit that on those principles,
Yes, thank you.
Thank you. So I've made the submission that for two reasons, this court is seized with a constitutional matter within its power. We submit that it's just and equitable that this court deals with the matter and considers it, and either grants it or doesn't grant it. But we submit it's not just and equitable, never in the interest of justice, to send it to the High Court trial. Now, I've got one last submission before I hear whether I have any instructions, and that is this. There was a complaint from Mr. Breitenbach that Thales had, in a sense, changed its case in reply. He said there was a nuanced, subtle change, whereas in the founding papers we complained. Our assertion was the four gentlemen were no longer an employer and they were not available. When we get to the replying affidavit, we broaden our complaint about non-availability. I have two answers to that. The first is, it's got no merit, the complaint, because what happened was, and we know what happened, in our founding papers we said we can't get the four, and we explained why, and the answer from Mr. Dana, confirmed by Colonel Dupoy, was this. They can't find the 4 in South Africa, and they've gone to Interpol, and they can't find the 4. So we, legitimately, and that's what replying affidavits are for, consider what he said in the answering papers, and we say, well, bearing in mind that Interpol can't find the 4, how can we find the 4? We're a private company.
But I thought you made that point.
No, I have to respond to Mr. Breitenbach's criticism of the reply. And in our reply, we invited, is what I call the Tantush principle. And I started on Tuesday morning with the proposition that if something is said in a replying affidavit, in respect of which a respondent is unhappy about, the PPC case, Scats JA, Tantush, in Kobo J in the Constitutional Court in the Tint matter, and they choose not to ask and apply for a 4th set of affidavits, this court will accept that which is stated in the reply. So for 2 propositions, and I started off this on Tuesday morning, and I said that in the replying affidavit, for the first time we came to the knowledge from the answer that we said Abrams was hell-bent on deciding in Thales, and we invited a response, nothing. Then the court will accept on all those authorities. And in PPC in particular, where at that time the Competition Commissioner Similani was maligned in the replying affidavit, and there wasn't a 4th application for a 4th set. And what Scats JA said, the Supreme Court of Appeal upheld in the Constitution, all those cases say, where that happens, if a respondent chooses not to deal with it, that respondent must accept that the court will find those facts set out in the reply as facts. So in our replying affidavit, we say we can't find these 4, and they are unavailable as a... And that, as Ms. Adhikari put to the court on Tuesday, Ms. Adhikari put to the court on Tuesday, this court is within the 4 corners of the pleadings. That is a pleading. So Mr. Breitenbach's open quote complaint, and he relies on Teletsani, which as I understand it, and I say it doesn't apply, and is no longer good, it doesn't apply to our facts. It's questionable whether it's good law anyway, bearing in mind certain constitutional dicta about it, but I'll leave that. But it certainly doesn't apply to our facts. So we would submit that on the basis of all the evidence, including in particular the answering affidavits, the arguments that you've heard from the National Prosecuting Authority, their own acceptance of their own unlawfulness, their own bad faith litigation, etc. Thales is entitled to Pres 1, 2, and 3 of the notice of motion. As it pleases the
My Lord, may I ask your Lordship's indulgence for 1 minute to deal with what my learned friend called his Naidu point.
Yeah.
My submission is merely this, that there is obviously a difference between this court and the regional court.
I think we made that point.
We accept that point.
Thank you.
We're aware of
Yeah,
that.
we are aware of that.
Now,
We wrote
can I
the judge.
say the second point is that there is no difference between this court and the trial court.
No.
They're the self-same
No,
court.
we are aware of that. That's why I asked him, I said to him,
Yes.
Thank you, my Lord, I appreciate
Yes.
it.
So I haven't dealt with, sorry, I do
Oh,
apologize,
okay.
I haven't dealt with one thing,
Okay,
which is the
okay.
strikeout application. And I do apologize. May I have 1 minute in response?
Yes, yes.
Mr. Breitenbach argued on Tuesday afternoon that that we weren't entitled to our strikeout application in respect of
Yes.
the references in Dana's affidavit to the Zuma affidavit. I want to make 2 propositions to the court. The one is, and I haven't read the application that's about to come in, but my learned junior drew my attention to something in Mr. Downer's answer in our case, which referred to something in the Zuma application. And I hadn't read the Zuma application, I couldn't find it. It wasn't a paragraph in So when Mr. Dana in our affidavit said, I refer to what I said in the Zuma in my Dana's affidavit in the Zuma application, do I trawl through thousands of pages, thousands of paragraphs in the Zuma application? And what we submit is this. On Swissborough, on Van Sale, a party's affidavit is both a pleading and the evidence. And it's not sufficient to refer by way of incorporation, by reference, in the way that Dana has done it. I don't know if the court has had an opportunity to consider our heads of argument on the point.
Yes,
but we stand by those heads, so that's the first proposition. The second proposition is, in this morning's application, Mr. Zuma's application to lead further evidence, opposed to by our learned friend, I'm not complaining, that's the way it is. We weren't served with it. And your lordship,
we can easily deal with that. We'll just try and find out from Mrs. Kakane,
but
whether
I'm
they need
complaining.
time.
And the third proposition, if I may just make the third proposition, then I'll sit down. If I may.
I have taken a long time.
Is this. I was thinking out aloud. Let's, for example, say our case, for whatever reasons, went on appeal by them or by us or whoever. Or part of it went on appeal, other part didn't. And now we get to the Supreme Court of Appeal, preparing the record. How do we prepare this record? And I'll leave it at that. What is the record? How is this court going to determine what's in our four corners of Ms. Adhikari's pleadings or what isn't? Do we take our answer?
The problem, Mr. Katz, is that we didn't read all the papers, Mr. Zuma's application. I think if you had gone through Mr. Zuma's affidavit, you would understand that these two applications are interlinked. You won't have that problem if you really.
And it goes back to my point I've been hammering about the indictments.
Yeah. No, if you actually read the affidavit, the founding affidavit of Mr. Zuma, the answering affidavit of Mr. Downer in Mr. Zuma's application, you'll see that there is actually no difference between the
well, if the court finds,
that's why I say to you, the difficulty that you will have, or the disability that you have, is that you did not give yourself time to go through Mr. Zuma's.
Then let me finalize with this. If the court accepts the way the NPA has pleaded,
but there's no way that you can separate this.
No.
There's just no way. There's just no way.
Well, my learned friend fairly did say, he indicated that in November last year, I did not agree on behalf of my client to a consolidation. Your lordship and lady.
No, we quite aware.
And that being so, I make one last submission. Yeah. If the court finds that the way that Dana has pleaded is satisfactory,
I must say to you, because we only received papers on a Tuesday, I think. It really helped us a lot to go through the papers. The way that the affidavits.
It makes our point. It makes my point.
Yes.
It makes exactly the point. And the point will be that your ladyships and your lordships will be will be rejecting that which was said by Joffrey J. in Swissborough, upheld by all the court. It's the most cited case in Pretoria.
Never mind, we'll look into the matter, but I can tell you that it was really, it helped to have the affidavits, everything set out in that way. It really helped.
Well, I can't comment on that, but it's not for me to comment on Swissborough.
1990. We'll deal with that.
If the court says that, I accept that. I accept that may be so. But all I'm saying is, Swissborough tells the world how to plead, and this is not the way to do it, as it pleases the court.
Thank you. Can we do we agree that we should take a short adjournment so that you can just have a look at the paper. Thank you. You see, Skakane, in the ordinary course, the applicant has a right to reply. Yes,
That's
yes.
what I'm going to talk about.
Okay, are you okay?
Mr. Trengov and I have agreed that in the interest of time, but also just because
Yes.
practically there is nothing to, I'll do my reply orally. There's no need to do a written replying affidavit because the issues are crisp and legal.
So the other issue which we are concerned about is the second prayer.
Okay. The second prayer.
Second prayer
Yes.
of notice of motion. Yes. The second prayer directing that the NPA files or the owner report an affidavit by an authorized person stating that the NPA is not in possession of documents and or information relevant to the permanent stay. We don't understand why should it be part of
This application.
Yeah, it's not key to us. We didn't think it would be a difficult thing. We're asking an organ of state to sort of confirm on oath that.
But
if,
can we consider this?
it's not my key. If an organ of state doesn't want to say that, you don't have to.
So the third thing is the issue of relevance of the document.
Yes, this document, the court will remember that I raised this issue at a time when Mr. Maduna's involvement was raised almost as if it's final. The court will remember that we've argued that there has been political interference. And of course, we've been ridiculed for the point. We've been told it's not true, it's a conspiracy. And then finally, a point was made in court that his role was limited to a particular meeting. So when we saw a document, which on the face of it is not written that it's privileged or confidential, and tells us that his role may not have been final as we were told. And in fact, at the time when we were told it's final, it looks like the very people who are telling us that they know about his role are conducting an investigation. It became relevant because it means his role as a minister with prosecution is something that has not been determined. It was the only limited role that we thought it played. It's for that reason that we felt it's relevant.
But the difficulty that we have, this document that has, you're seeking leave to be received as evidence in these proceedings, seems to rely on other document of Mr. Suklal.
I'm making a very simple point here. I'm saying you've been told about the finality of the role of political players. I'm saying to this court, you can find what you want to find. When you were told about his role, that it's final, I'm saying you read their answering affidavit. They tell us now in the answering affidavit that when they said that, they knew that they are still investigating. They say Mr. Duploy claims privilege because they are investigating the roles of those politicians mentioned in that document who were who are alleged to have been involved in the prosecution or briberies related to this prosecution of my client. It's for that reason only that I raised this issue and its relevance, is that the issue of political meddling and interference is not finalized. They say it themselves. That is the relevance of this. And the third point and last point, we didn't think it would be difficult for an organ of state that has for a long time been telling us about this constitution and transparency to really refuse to show a letter to the other side so that the judges can ventilate the matters fairly and openly with all the information they have. But I'm in the hands of the court. That is our submission about its relevance, and the court can decide not now in good time whether if these documents that really will keep coming, because they don't give us the documents. We've been complaining about it. I'm alerting the court right now, and the prayer number 2 that the court says is relevant. It's relevant exactly for the refusal of an organ of state to tell us that if next week we get a document again, because we don't know when people are not open, what you get next.
Can I ask this question, and that will also be my last question. This document seems to be an investigation by the NPA. So they are in the process of conducting their own investigation about this allegation, as I understand the letter. Now, can we say that the NPA knows about the political meddling if we accept that this letter seems to be an investigation?
I'm making this point. I'm saying when they stated on oath to you that there isn't political interference, especially on the role of Mr. Maduna and other politicians, they themselves are investigating that role. It's not final.
Yes.
That's the point I'm making.
Yes.
That's all I'm saying.
Thank you.
And I'm in the hands of the court. If the court believes that it shouldn't be, it will ventilate the matters now and in the future without these documents, because an organ of state does not want to give them. It's fine. Those are submissions.
Thank you. Sorry, Mr. Katz, you had sight of these documents.
I have two comments to make. The first is it's not clear to us that my client, although implicated in the letter or the affidavit of Mr. Sukla, has any right to take part in this debate. That's the first issue. And I wouldn't want to make submissions in respect of an application in respect of which my client is not a party. The second issue is that as of May 2019, as of now, we know of no such investigation, no such charges against my client. May I just take an instruction on one issue?
Yes.
So in conclusion, one, I have no right to make submissions, and two, as a matter of fact, we know of no such investigation and we have not been charged with any of the crimes that are seemingly underpinning the letter from Mr. Abrams.
Thank you, my Lord. Lord, may I, as a starting point, address very briefly the state's obligations to make disclosure of documents in these circumstances. And there are two sets of rules that may govern it. The first is the rule that governs application proceedings. The general rule is that there is no discovery obligation in application proceedings. I refer in this regard to the case of molded components. It is molded components and roto molding South Africa v. Koukarakis, that's Coucourakis, 1979, volume 2, SA, page 457, W, at 470 D to E. where His Lordship, Mr. Justice Botha, said in a paragraph which has been very frequently endorsed by our courts, he said the following: in application proceedings, we know that discovery is a very, very rare and unusual procedure to be used, and I have no doubt that it is sound practice and that it is only in exceptional circumstances, in my view, that discovery should be ordered in application proceedings. So that is the starting point in proceedings of this kind. It might be contended that in criminal proceedings there is the different set of rules that govern access to the docket. On my understanding of Chabalala's case, access to the docket is normally granted for purposes of the conduct of the trial, not for purposes of preliminary skirmishes. But assuming for the moment that it does apply, it does not include an obligation to disclose documents of this kind, which is part of the prosecution's pre-trial work paper. This is a communication between the NDPP and the Hawks for purposes of an investigation. So this is so-called work product, which is privileged and is excluded from what is discoverable under the docket privilege. If I may refer in that regard to the case of NDPP v. King, it is in the All SA reports, 2010, Volume 3, All SA, 304, paragraphs 2 and 30. If I may firstly refer to paragraph 2. The blanket privilege, that's the old blanket privilege, the blanket privilege has not been replaced by a blanket right to every bit of information in the hands of the prosecution. Litigation privilege does still exist, also in criminal cases, albeit in attenuated form as a result of these limitations. Litigation privilege is in essence concerned with what is sometimes called work product and consists of documents that are by their very nature irrelevant because they do not comprise evidence or information relevant to the prosecution or defense. And then in paragraph 30, at the end of that paragraph, the second half of it, it says, King seeks a motivated list of opinions by prosecutors, notes on legal research, and copies of judgments, reported and unreported. These documents are clearly relevant to the prosecution, but they are not relevant for purposes of making full answer and defense. In other words, as mentioned at the outset of this judgment, most of the material covered by litigation privilege in criminal cases would in any event not be discoverable because the material is not germane to the conduct of the trial, i.e. is not relevant in the sense discussed. Now this document is precisely that. It's a document subject to litigation privilege because it's a communication within the various organs of the state with a view to future litigation. So that's the starting point. As far as this particular document is concerned, it would be subject to litigation privilege, and it seems on the face of it that it may have been unlawfully released to the applicants. The applicants have not told us when they got it or from whom they got it. But if you refer to our answering affidavit in paragraph 15, the point is made that the document seems to have come either from the NPA or from the Hawks, and whether it's the one or the other would be unlawful. So it's privileged and seems to have found its way into the hands of the Zuma camp by an unlawful disclosure. That in the first place. In the second place, it is entirely irrelevant. It speaks to accusations made by Mr. Suklal about the role of Mr. Maduna in the Tint prosecution. There is not a word said about the Zuma prosecution. So it is entirely irrelevant to the Zuma prosecution.
I think that was the question that my brother asked earlier as to the relevance of the document.
No, exactly. It is entirely irrelevant. And my learned friend is mistaken. Nobody said Mr. Mr. Maduna, nobody characterized, I particularly didn't characterize Mr. Maduna's role in any particular way, other than to refer you to those paragraphs which describe his role, and that is the evidence before the court. So, to say that he played some sinister role in relation to the prosecution of Tint has absolutely nothing to do with this case. But then, the letter that they seek to have admitted merely recites allegations made by Mr. Suklal. It doesn't make any allegations of its own. And the Suklal affidavit is a matter of public record and has been in possession of the Zuma camp for years. And our affidavit makes that clear. The Suklal affidavit, in our answer, paragraphs 17 to 19, you will see that the Suklal affidavit was made for purposes of a court case. And that is a court case in which Mr. Zuma, both in his official capacity and in his personal capacity, is a party. So it is an affidavit filed in a case in which Mr. Zuma was a litigant. And in that capacity, the affidavit was filed in that litigation on the 16th of November 2016. It's 2.5 years ago. So that affidavit has been available to him for 2.5 years. The state only subsequently obtained copies of it. And what it then did, our paragraphs 18 and 19 tell you, is that Colonel Deploy gave the accused copies of the Suklal affidavit in July last year. So the Zuma camp has been in possession of the underlying affidavit since November 2016, and in the context of this case, since July last year. So for them to apply at the death, at the 11th hour, on the last day of argument, for admission of a document which reflects these allegations is, with respect, utterly unjustified. As for the mandamus that they seek, that is, the premise of the mandamus is that there is a general duty of discovery on the state. Well, there isn't. That is what King said and what Mulder Component said. And it is in any event not an issue that needs to be raised at the very end of this application. If the Zuma camp, for purposes of the trial, want further discovery, then they must bring a proper application and motivate it.
Well, they would be entitled, if the matter proceeds in any criminal matter, to ask for further and better particulars,
Indeed.
Which will include any other documents relating to the offences or investigation in itself.
Indeed, my lady. And there has been much toing and froing about documents anyway, but it's a massive enterprise, and they can come for more if they feel that they haven't been given what they're entitled to. But to do it on the last day of this application is, with respect, quite out of place. We ask that the application be dismissed with costs.
We persist with our application.
I hope this is the end of the arguments, and the court will take time on all aspects which have been raised.
Thank you.
Thank you.
Ya uzongiphathela